Hello everybody, Allistair A Trent here on February 5th, 2020, and today I'm going to be speaking about or making an argument relating to tenants who have pets in no-pet condominiums or condominiums which restrict the size or other characteristics of pets. This case or this argument was originally developed for a client who was facing this difficulty. However, that case settled, and I thought I would make the argument because it's of general interest and hopefully will be of assistance to other clients who are facing similar issues in the future. So the facts on which I've based this particular argument are sort of generic facts, which is that the rental unit is located in a condominium in a multiple unit building, and occupancy of the buildings governed by rules made pursuant to Section 58(1) of the Condominium Act, which authorizes a board to make rules in order to promote the safety, security, or welfare of the owners and the property or assets, if any, of the corporation, and also to prevent unreasonable interference with the use and enjoyment of the units, common elements, or the assets, if any, of the corporation. In this case, there was a rule that related to animals and provides that any dog moving into the building shall not exceed the maximum weight of 12 kilograms or 25 pounds. The tenant submits a rental application prior to leasing the unit, which didn't disclose that they owned a dog. However, an email subsequently came into possession of the landlord indicating that the tenants intended to move their dog into the unit from the very outset of the tenancy. And this is, again, a common situation faced by landlords. If you Google, can you have a pet in an Ontario rental, you'll quickly discover that landlords can't evict tenants for having pets. However, they can refuse to rent to tenants who have pets. So the easiest workaround to that is to simply not tell the landlord you have a pet, get accepted into the apartment, and then bring the pet in anyway. And as we'll soon see, that can lead to significant difficulties for the owner in cases where it's a condominium and the building has restrictions on pets. After taking possession of the unit, the tenants move a dog into the unit, which is in excess of 25 pounds and had been brought from another location. And immediately upon the condominium discovering this, the landlord's agent and property manager received a letter from the solicitors from the condominium indicating that the dog was in violation of the rules and that the condominium would commence legal action against both the owners and the tenants if the tenants didn't voluntarily remove the dog. So as a result, the landlord served an N5 notice of termination on the tenants requiring them to remove the dog, and when the tenants did not do so in the time provided under the notice, the landlord made application to the board. So the main issue in this case comes from Section 76 of the Residential Tenancies Act, which is the section that prohibits landlords from evicting tenants based on animals. Just for interest's sake, this section was brought in the late 1970s after the public outcry from what was called the Fluffy case, Fluffy being named after a cat, where an elderly woman in an apartment building owned a cat and the landlord evicted her, and it created such a public outcry that legislative amendments were put in place prohibiting landlords from evicting tenants because of pets. And those legislative amendments have basically remained in force and unchanged to this day, and are currently contained in Section 76 of the Residential Tenancies Act, which prohibits the board from issuing an order terminating a tenancy based on the presence, control, or behavior of an animal, unless the behavior of an animal of the same species has caused or contributed to the substantial interference claimed. And again, the operative part here is that it has to be the behavior of the animal that it causes a substantial interference. The mere presence of the animal doesn't trigger the right to evict. In this case, however, it is argued that in the case of a condominium building having restrictions on pets, I should say, it's argued that the tenant substantially interfered with the landlord's reasonable enjoyment and its lawful interest, and the enjoyment of the premises by other residents of the condominium by the mere presence of the dog, which is in contravention of the condominium rules. And there's a further argument to say that the fact the landlord has been billed significant legal fees by the condominium and placed at risk of litigation by the condominium corporation in itself substantially interferes with its enjoyment and lawful rights, quite apart from any other factor involved. And there's a case cited there. However, that case also dealt with a situation where the dog was barking. It's respectfully submitted that to disregard the interest of other owners and residents who specifically chose to live in a building which doesn't allow large dogs is likewise an interference with their reasonable enjoyment of the premises, irrespective of the behavior of the dog or whether or not it's barking. And again, citing Section 58(1) of the Condominium Act, the Condominium Board is entitled to make rules governing the use and occupancy of its units, provided that those rules are to promote the safety, security, and welfare of the owners and the property assets of the corporation, or to prevent unreasonable interference with the use and enjoyment of the units, the common elements, or assets, if any, of the corporation. Excuse me. I should note here, just as a matter of interest, that there has been a similar line of cases under the Condominium Act, which, again, are to like effect to the prohibition, in the sense that in cases where tenants have house cats or fish, or rather residents of condominiums have house cats or fish or other types of small animals that don't go outside and don't have any potential to affect anybody else in the condominium building, the courts have struck down prohibitions against having those types of animals. However, in the case of a restriction on dogs, or the size of dogs, or breed of dogs, etc., those are generally enforceable. Provided that the rules are reasonable and not otherwise inconsistent with the provision of the Condominium Act, they're valid and enforceable. A rule placing a maximum limit on the size of pets is not unreasonable and is valid and consistent with the legislation. And this comes from Your Condominium Corporation and Dvorak, which is a 1997 decision of the Ontario Court of Appeal, which is still good law, and Simcoe Condominium Corporation and Dominelli, which is a later 2015 decision of the Ontario Superior Court. So the result of this is that either the condominium or landlord is entitled to apply to the court under the Condominium Act to obtain an order for compliance with the rules against the tenants, and in fact it can be seen that orders are regularly made requiring residents to remove dogs which are in violation of the rules, again citing Section 134 of the Condominium Act, which is the authority to make application to enforce compliance, and again the Simcoe Condominium and Dominelli 2015 decision of the Superior Court, although there are a number of decisions to similar effect. Those decisions are all made, however, against owners of condominiums and not against residential tenancies, and the issue here comes in from the interplay of the Condominium Act and the Residential Tenancies Act and the apparent inconsistency between them. So in that regard, it's submitted that both the Residential Tenancies Act and the Condominium Act are statutes dealing with the same subject matter, namely the regulation of the behavior of occupants and residents of condominium buildings. And the acts therefore need to be read in pari materia, or together, and interpreted in a manner consistent with modern commercial realities that maximizes the application and effectiveness of both to the extent possible and avoids inconsistent and absurd results. Insofar as the modern commercial realities goes, as I say, the prohibition against evicting tenants contained in Section 76 came about in the 1970s, before there were even condominiums, and it can't possibly have taken into account the modern commercial realities where condominiums form a substantial part of the rental market in Ontario currently. Nevertheless, the purpose of the Residential Tenancies Act includes, among other things, to provide for an informal method of resolving landlord and tenant disputes. So to require the landlord or condominium to apply to the Superior Court, which is both far more expensive and far slower, to obtain relief that is otherwise within the jurisdiction of the board is fundamentally inconsistent with that purpose, which is one of the prime objectives of the Residential Tenancies Act. Furthermore, what we're dealing with is essentially the strict wording of Section 76 of the Residential Tenancies Act insofar as the behavior of the animal being the only factor to be considered as opposed to its presence. And in interpreting that statute, courts have to have regard to principles of modern statutory interpretation, which favors an approach that accords with modern commercial realities over the strict wording of a statute alone. And the Supreme Court of Canada has repeatedly held that it's necessary to consider the entire context of legislation before settling on what appears to be at first blush to be the plain meaning of a legislative provision. And a number of cases cited from the Supreme Court of Canada that reiterated that principle, the latter being Rizzo and Rizzo, which is one of the most famous ones, and citing from that decision, statutory interpretation cannot be founded on the wording of the legislation alone. An isolated plain meaning approach can lead courts to interpret statutes in a manner that produces absurd results. It's a fundamental principle of statutory interpretation that the legislature does not intend to produce absurd results, and courts have repeatedly departed from plain meaning when interpreting legislation to avoid absurd results. And this entire dicta and ratio is actually from a decision of the Court of Appeal in 2018, Solar Power Network and Clear Flow Energy. Furthermore, where two statutes are inherently in conflict, the principles of statutory interpretation urge an approach which allows both statutes to maintain their maximum application and effectiveness. Schnarr versus Blue Mountain Resorts, another decision in 2018 of the Ontario Court of Appeal. So getting to the absurd result in this case, the first way in which we say that allowing the tenant to keep the dog leads to an absurd result comes from the nature of the leased interest itself, in the sense that the landlord only has an interest in the building to occupy the unit subject to the rules and regulations of the condominium. It can't lease out an interest that's any greater than the interest it has, and the interest that it has isn't varied or extended or changed in any way by virtue of the fact that it's leased to a tenant. So that it would be an absurd result if the landlord is taken to lease an interest in the property that's any different or greater than it has itself. If the landlord can't have a large dog in the premises and it can't give that right to a tenant to do so, and to hold that it does is itself an absurd result. Furthermore, to allow the tenant to keep a dog in breach of the condominium rules is unfair to other owners and even tenants who specifically elected to live in a building which prohibits large dogs, or in any event to enact rules that prohibit large dogs in the building. It defeats the entire purpose of the Condominium Act in preventing members of the condominium from enacting and enforcing rules for the benefit of the building, and leads to the absurd result where tenants in the building have higher rights than the owners themselves. Furthermore, it should also be noted that it defeats the right of the condominium owners and residents to enact rules, because I should think that it matters very little to an owner who lives in the building and who's afraid of large dogs, etc., whether the large dogs are owned by a tenant or another owner of the building. The fact is that they've all come to the conclusion that they want to live in a building without large dogs. And so, again, to allow the tenant to have large dogs simply because they are a tenant overwrites the right of the owners to enact rules and that they deem in their discretion, which they have a right to do under the Condominium Act, is for the betterment of their community. The next argument to be made is a compliance remedy as opposed to or an alternative to eviction, so that even if the prohibition in 76 were to apply to prohibit the eviction of the tenant, there's no prohibition in Section 76 against an order being made requiring the dog to be removed so as to comply with the condominium rules. This order would effectively be the same result as a landlord would be entitled to if it applied to the Superior Court under the Condominium Act. And again, if one's going to have a strict wording of Section 76 to say that it has to be the behavior of the dog and only the behavior of the dog can lead to eviction, then I would ask that you also have a strict wording of Section 76 to say, well, it's only eviction that's prohibited. A compliance remedy isn't prohibited by Section 76, and there's nothing in 76 that prohibits the board from ordering the dog to be removed. Furthermore, in the event that such an order were made and the tenant were to breach that order, application could be made under Section 78, which is a provision that allows you to apply where a tenant breaches a previous order, and any application under Section 78 is not something that's governed by Section 76, which only applies to other types of applications. So that would also be enforceable to evict the tenant if the tenant didn't comply with the order and remove the dog. If the condominium and the landlord have the substantive right to have the dog removed, it should make no difference to which court they apply to accomplish that objective. To hold otherwise leads to an inconsistency and makes substantive rights subject to procedural election. In other words, in order that if you apply to the court, you have the right to have the dog removed. If you apply to the board, then you don't, and that makes absolutely no sense. Your rights should be your rights, regardless of where you decide to enforce them. Again, Section 1 of the Residential Tenancies Act provides that the purposes of the Act are, amongst other things, to balance the rights of residential tenants and landlords and to provide an informal adjudication of disputes. Moreover, by Section 168(2) of the Residential Tenancies Act, the Landlord and Tenant Board is granted exclusive jurisdiction over those matters in which jurisdiction is conferred by the Residential Tenancies Act. So that to refuse the order to remove the dog where the landlord is otherwise entitled to an order for removal if it applied to the court is inconsistent with the purposes of the RTA and contains an internal inconsistency within the legislation itself. And finally, a statute should be given its plain and ordinary meaning, except where to do so would be inconsistent with the overall purposes of the Act or would offend the absurdity principle. So, in light of all of the foregoing, it's respectfully submitted that an order should be made terminating the tenancy and evicting the tenant, or in the alternative, even if the board's not inclined to evict the tenant, the dog should be permanently removed so as to comply with the condominium rules, all of which are respectfully submitted. And thank you. I hope you found this informative. If you have a situation or a similar situation dealing with pets or any other situation dealing with residential tenancies in condominium buildings or otherwise, I invite you to call my office at 416-628-4835 or visit my website at www.investrent.ca. Thank you for joining me.